Action.
Okay, so good morning, John and Cyrus. I am Brian Spears, the president of the Commonwealth Lawyers Association, and it's really great to have an opportunity to speak to two leading international practitioners about the sort of difficulties that the COVID-19 pandemic is causing for the administration of justice and the presentation of courts. So could I invite each of you please to introduce yourselves. John, who are you?
Well, good morning, Brian. Good morning, everybody. Or good afternoon, wherever you are. My name is John McKendrick, QC, and I'm a London-based advisor and litigator. I'm called to practice in 4 Commonwealth jurisdictions, and I advise and represent clients internationally and across the Commonwealth. I have the pleasure of being an executive council member of the Commonwealth Lawyers Association, and I sit on the Bar Council's International Committee.
Excellent. And Cyrus, who are you?
Brian and listeners and viewers, I'm Cyrus Larizade, QC. I am the chair of the Family Law Bar Association of England and Wales. We have approximately 2,000 members. I'm responsible really for the administration of family law work from the bar's point of view. I'm involved very much in the COVID-19 crisis. I called the situation on the 18th of March with an email suggesting that my members were no longer going to be going to court in person, and started setting up remote platforms across England and Wales. And I have some evidence and experience of the international work and the impact on international work of COVID-19.
Well, that's great. We seem to have two people in the right frame, both literally and in the course of your work. John, you have experienced difficulties in attending court and in participating using technology in the Caribbean, where you spent some time. Could you explain a little bit about that?
Yes, between 2016 and 2018, I was the Attorney General and DPP of the British Overseas Territory of Anguilla. And as many of your viewers will know, we suffered devastating consequences following Hurricane Irma in September 2017. Following the destruction and the loss of power and communication to the island, we faced very significant justice concerns, both from the administration of civil, criminal, and family justice, down to really the nuts and bolts and brass tacks of how did you manage to function a magistrate's court? How could you print out indictments and bail forms? Where would the magistrate sit? And so we faced a number of difficulties, and certainly one of the solutions in the Caribbean, and this was not simply Anguilla's experience, it was an experience across the Eastern Caribbean, from St. Martin, Anguilla, the British Virgin Islands, Turks and Caicos Islands. We relied a lot on technology, and particularly on Skype. And the Eastern Caribbean Supreme Court Court of Appeal is based in St. Lucia, but our appellate work had to proceed by Skype hearings, which were effective. And some of our other High Court matters, criminal and civil, also had to take place by way of remote or virtual hearings in Skype because of the then absence of the resident High Court judge.
So as with actually so many things, we have learned a little bit from the Caribbean, and you have taken what your experience was then, I understand, recently into a hearing, or more than one hearing, in London using technology. Could you explain a little bit about that, please?
Yes, since the COVID-19 crisis hit the English and Welsh court system in the middle of March, I've been involved in 3 hearings. One was a 5-party trial before Mr. Justice Mostyn to determine a medical treatment issue for a patient. It involved about 8 witnesses of fact and 3 experts, parties represented by counsel, and the 3-day trial was conducted by way of Skype for business, with all parties and witnesses attending remotely from their homes or, where possible, their offices. I've also been involved in an LCIA arbitration, a one-day hearing involving two parties and a witness who was overseas, who was cross-examined, and also a lengthy telephone hearing as well to determine other matters. So those are three different experiences through Blue Jeans, Skype for Business, and BT Meet Me. All were overall successful, but we have to recognize that different experiences of these different hearings often depend upon who you are and what your role is in the justice system. My overall view is for most parties, particularly professional parties, and for lawyers, counsel and solicitors, and for judges, it has been a relatively satisfactory manner for the administration of justice. But I'm aware, certainly from the trial that I was involved in, that a lay party didn't find it as satisfactory as some of the other, what I would call professional parties. And we must be very mindful of that. And we must ensure that the administration of justice delivered remotely or virtually is very much alive to the particular demands and needs. And I know Cyrus probably has an interesting perspective on this, because the administration of family justice and welfare justice is somewhat different to the administration of general civil justice.
Well, let me just turn then to Cyrus. Cyrus, you've heard John's experience, both in the Caribbean and more recently here. But in matters of family law, there's often emergencies, there's often care for children. And what has been your experience, both as a policy and involving the Family Bar Association, and perhaps you've had recent experience that you would feel able to share as to the use of technology?
Sure. Well, Brian, really before COVID-19 and its outbreak, the family justice system was using remote technology, was using telephonic hearings, was taking evidence from abroad using a variety of basic platforms. It wasn't always easy. Video link required sometimes a secure bridge, and there were times when the reception was really not very great. Experts were giving evidence from different parts of the UK using remote technology, but again, video link set up using the court system. And so we had some experience, much more so than, say, the criminal bar and the criminal justice system. But we were simply not prepared for what was about to be unleashed on us in the week of the 16th of March. And having recommended that our practitioners should not attend in person, we had to then work out what remote platforms were available and which cases should be the priority cases. And so what happened was essentially a series of telephonic hearings, and those were basic hearings in which cases were adjourned that were listed, or there was some basic case management directions given on the line. And they rarely involved the participation of the parents and the families on these lines. And then within days, we were using Skype for Business. We set up Zoom and LifeSize, and Microsoft Teams became something that was being used. And so we began to actually take evidence using these various forms. Now, John's absolutely right that one angle is different to another. And one of the concerns that we've had is that some trials have progressed, but without necessarily taking into consideration properly the impact on the lay clients, on the families of proceeding using the technology. Now, some trials have progressed successfully, balancing everything, including the impact on families. And of course, delay is often not in the best interests of children and families. But also, there is Article 6 and the right to a fair trial. and the participation of clients using intermediaries, interpreters, sign language facilitators in these cases are important. I have received a great deal of feedback across the regions and in London about cases, some success stories and some disasters. Removal of children from their parents with telephonic hearings when the mother is with the children in the same room as evidence is being taken, not being able to participate properly in the process. Mm-hmm. Lawyers who don't have the opportunity of proper instructions, being able to share paperwork. And so we're dealing with things, Brian, in increments, because that's the only way that we can manage this. And so we are beginning to look at the different platforms, which are good, which are not so great. And also, how do we communicate paperwork to clients, and how do we take instructions? How do we support our solicitors, many of whom can't take instructions from clients and visit them? How do social workers assess risk and assess the situation in the homes? And how do experts meet with children and vulnerable parents and vulnerable adults? And it's a brave new world, as John and I described it in our conversation together. And it's all relative, and we have to do our best. But the President asked me last night, Sir Andrew McFarlane, to put together a set of questions on the first few weeks of learning in terms of the remote hearings and in particular live evidence and how that took place, and when it didn't take place, why, and how can we improve the system. And we will report back to him later on in April with a view to there being a proper practice direction or guidance on this in early May. He's already done his very best to help us. But I think now that we've got some learning, including cases that John has been involved with, perhaps in the Court of Protection and otherwise, that we can learn from different practice areas and to try and improve. But I'm pleased to say that family law and the family justice system is somewhat ahead of the game, but we have a great deal to learn, and it's great to be able to collaborate with other jurisdictions, and that's why I was particularly keen to join this discussion today.
Well, thank you, Cyrus. This is intended to be a relatively short discussion, but a precursor of a wider interest of the Commonwealth Lawyers Association in court-based issues arising from the current pandemic constraints. Just to wind up, John, if I could turn to you, in responding to Cyrus and taking in your own experience, are there any other messages, concerns, or issues that you would like to at least put out there without necessarily yet having the answers to?
Well, first of all, I entirely agree with Cyrus that there are some extremely difficult sensitivities with the administration of family and broader welfare justice that are going to be looked at very carefully, must be looked at very carefully, and they are extremely difficult. But speaking more broadly in terms of overall civil justice, for me, many of these issues are in fact rule of law issues, because we must have a functioning court system and we must have a functioning judiciary. And I feel that very strongly from my experience as Attorney General in the Caribbean. In neighbouring islands, there was mass looting, rapes, attacks, and society simply, in some of those islands, crumbled. One of the successes of Anguilla was throughout we had a continuing system of parliamentary democracy and just about a functioning court system to take urgent decisions in civil, criminal and family justice, and to hold the government to account in the use of the measures it was taking in response to the emergency situation we faced. So we must ensure, however difficult, whatever the challenges are, that the administration of justice must carry on mindful of those who are vulnerable and at the margins of society. Because at the end of the day, the administration of justice in many ways is often there to protect the vulnerable, and they need it more than ever at these very difficult and challenging times.
Well, that's excellent, because it allows me to remind everyone that the Commonwealth Lawyers Association does seek to uphold the rule of law throughout the Commonwealth. I endorse the views that you've expressed, John, about that. I have been informed by Cyrus's insight into the type of issues that can arise in family law, and I am sure this discussion not only will take place on a continuing basis and on a wider basis, but must take place to ensure that the rule of law and the administration of justice is upheld throughout the Commonwealth. So may I say thank you, John, and thank you, Cyrus, for participating at short notice in this little event. And I look forward to catching up with you both again soon, particularly Cyrus, after you have formulated your questions to the President of the Family Court, and you can update us on progress there. So you might both take the opportunity to make a closing remark and to say cheerio.
Cheerio.